Hello and good afternoon, everyone. I'm going to ask the panelists to come on their videos if they can. There we go, we're all here. And just sound checking, can my panelists hear?
Good morning, or good afternoon, I should say.
Afternoon. We're a little bit ahead of you, Leanne.
Gone quick.
Good stuff. Well, we'll start then. Hello, my name is Thea Osmund-Smith and I'm a specialist planning barrister and a member of the Women in Planning West Midlands Committee. We're delighted that you can join us. We're sorry not to meet you in person, but having it virtually means that so many more of you can attend and listen in while you're having your lunchtime sandwich, soup, or even a glass of wine. There is no judgment here. So I encourage you to use the chat and question functions, but please note that your name and comments may well be visible to everyone. And if we choose your question at the end, then we might name you. So just be mindful of that. Please also only use the question function for questions, otherwise we might well lose track of those. But I do encourage you to use the chat function to share comments and views. That's an important part of this discussion. Sharing knowledge is a good thing, but please don't be rude, no effing and jeffing. I know that CIL can bring out the worst in people. Finally, please do sign up to our wonderful, supportive and inclusive Women in Planning network at www.womeninplanning.org. I'm hoping the link for that will go into the chat momentarily. And at that link, you can hear all about events taking place across the network and get involved in what Women in Planning have going on. So I'm going to introduce you to this brilliant panel of women that I am privileged to call my colleagues and my friends. And I'm going to introduce them in turn with a question by way of a little get to know us, if you will. So I'm going to start with Leanne. And Leanne, hello, good afternoon.
Good afternoon this time.
Good morning. And my question to you, Leanne, is what has been your best day as a planning barrister?
Wow, I mean, that's quite a difficult one. There's quite a few things I'm sure that all of us could pick out. But for me, it's a bit of a geeky thing. Traditionally for barristers, you're only supposed to carry a wig and gown in a blue bag, but you can have a red bag if a silk gives it to you. And they're only supposed to give out 2 or 3 in the entirety of their career. And I got given one by a silk recently. It's for exceptional work on a case. So for me, that felt very much like a career-defining moment. Very proud of that. So I think that would be the one that I'd pick out now, Thea.
That's a great one. Thanks, Leanne. Sioned, I'm over to you next. And I know that you almost weren't here today because you were going to be down a mine. And on that theme, what has been your strangest site visit to date?
Thanks, Thea. Good afternoon, everyone. Well, I had a very interesting site visit yesterday, I have to say, which I probably should tell you all about. I was out on site with Richard Kimberlin QC, and we wandered around a farmstead which was derelict, to be honest with you. And we're acting for an appellant in a forthcoming inquiry regarding a substantial redevelopment of a listed building there. So Richard and I were wandering around this farm. We got completely soaked, and that was inside the house as well as the outside of the house, because there was some beams caving in the ceiling. But then we went for a very nice lunch afterwards, and whilst we were there, we ran into Simon Cowell, and I can confirm that he still wears a black polo neck and very high-waisted trousers. So yes, all in all, never a dull day in this job, is there?
I love that. You just ran into Simon Cowell at lunch. What a story. Brilliant. Odette is next, and Odette is Nina's brilliant pupil who joined us last year, and so brilliant that everyone in the group is jealous that Nina gets to be her pupil supervisor.
I'm sure.
She's so excellent. My question then for you, Odette, is what has been your best day of pupillage so far?
Like Leanne, there's a lot I could say, and I'm not just trying to please you when I say this, Thea, but I think it was probably the end of that 2-week solar farm inquiry we did before Christmas. I'd seen a few planning inquiries before, but I'd always kind of been an observer, and it was all a bit of a mystery to me what was going on. And this one, I really felt like I was involved. I was participating, I was part of a team, and that was really nice. And I was just sort of going home on the train. I picked up some Lincolnshire poacher at the market in Newark. I just thought, wow, this is a cool job. We're really doing something that can change this area. And yeah, I think it was that.
Okay, I love that. My favourite part of that inquiry was the free champagne that we managed to one night in the restaurant. But, you know, I like your story too. And then Nina, over to you then, please. Question for you is your strangest case.
There's a sad surfeit of them to pick from. The most obvious, because it has the weirdest facts, is the prosecution, successful prosecution, I should say, of people for regularly blocking a sewer with ladies' underwear. They kept doing it, and so there's no choice but to prosecute. So thankfully it ceased after that. But I'd say the weirdest one, because it has such a happy outcome, as does that one actually, no more blockage with ladies' pants, is the time I got a case, and it's one of those ones where you think, oh my God, someone had constructed a house without consent, brand new, on an exposed slope overlooking a beautiful valley in a national park, and they wanted me to get them retrospective permission. You'll remember this, Thea, because I called you from the hotel room the night before the inquiry, because I knew you'd make me feel better, and you did. And still slightly shocking to me, but we did get them permission. So very weird, very, very weird, but a very happy outcome. Beautiful house, beautiful location, beautiful clients. They were lovely. So I think that's the weirdest one, but just because of the shock of the outcome, we got it done.
Brilliant, thank you. Well, with those introductions then, we're going to turn to our first presentation, and Sioned is going to take control from here and tell us all about Mclaren.
Okay, thanks very much everyone, and thank you for your patience. So hopefully you can see the slide now, which has a blue rectangle on it. So I'm going to be covering the case of Mclaren and Woking Borough Council, which was heard last year before Sir Ross Cranston sitting as Judge of the High Court. And it featured our very own Hashi Mohammed acting for the claimant in this case. So the claimant here were the Mclarens, and they owned a family business which was in half of the land depicted in blue on this slide. That forms approximately 50% of the site within the red line. The other half was owned by a company called New Central, and they applied for planning permission on the entirety of the site within the red line depicted on screen. Now, there's an important sequence of events in this case, which you need to know about. So in 2017, the local planning authority resolved to grant a planning permission subject to the Section 106 negotiations on payments for mitigation for the Thames Basin Heath Special Protection Area, and also for an affordable housing overage. From 2017 to 2020, there was then an exchange of emails between the parties and negotiations, and by the parties, I mean the claimant and New Central, and negotiations about whether Mclaren would in fact sign up to the Section 106 agreement, whether they would sell the land or be part of a joint venture. Ultimately, Mclaren refused to enter into the agreement, and the Section 106 agreement was then only entered into between New Central and the local planning authority, and only bound New Central's part of the development site. This was done some 3 years after the initial resolution to grant in 2020. So there were 4 grounds of challenge in this case. The first is the most important for our purposes, and that was that there was a legally inadequate Section 106 agreement which failed to provide reasons for the exclusion of the claimant's land. That's Mclaren's land. Secondly, that there were a material change of circumstances between 2017 and 2020. Thirdly, that the claimant had a legitimate expectation to be part of the Section 106 agreement. And fourthly, that there was a failure to comply with procedural notice provisions in the DMPO. Okay, and the key finding of the case for our purposes is that there was no error in granting planning permission for a block of flats that encompassed the 2 pieces of land where only the owner of one had executed the Section 106 agreement. So I want to give you some helpful takeaways if I can. So firstly, I think it's important that all parties very carefully consider the land interest on any particular site. The local planning authority will always need to be satisfied that there is sufficient land bound into the Section 106 agreement to mitigate the impacts of any specific development. So the headline remains that in many cases, the mitigation may not be achievable unless all the relevant interests for the whole development site are party to the Section 106 agreement. However, and as this case illustrates, there may be cases where appellants or applicants for planning permission can take some reassurance for those who are difficult and who won't sign up to a Section 106 agreement and to get the 106 agreement over the line. In those circumstances, it's worth asking yourself the question, what is necessary really here to mitigate the impacts of the development, and what are the triggers in the obligation. There may be cases, as here, where the obligations would be triggered regardless of whether Mclaren's land were party to the agreement or not. The affordable housing contributions here and the SAM payment were triggered on commencement, and that was triggered when New Central commenced the development. So when do you need to be worried? So if you have a site where, for example, you're bringing forward 200 houses, 100 on parcel 1 and 100 on parcel 2, and the affordable housing contribution is triggered on delivery of unit 105, for example, then that would be a circumstance in which you need both landowners to be party to the agreement. However, if you have, for example, an education contribution, which is triggered on occupation of the first unit, which could come forward on that one section of the land, then you may not need the second landowner to be party to the agreement. So the overarching message here is, like I say, just be very careful of assessing the land interests and indeed the triggers that are required in the Section 106 agreement, and who actually needs to be party to the agreement in order to get it over the line.
Super, thank you very much, Sioned. So it seems to me then the case is still very much we need to be careful about which land we're binding, but the particular facts of this case led to the conclusion that those obligations could be provided notwithstanding the other half of the site, as it were, not being bound. Okay, great. Well, Leanne, I think we're going to move on to you to hear about the fascinating topic of housing land supply. And I say that genuinely. I find this fascinating.
Absolutely. I mean, don't we all love a bit of 5-year housing land supply? And a link to that, don't we all love a bit of the Spice Girls? And I hope everyone's going to say yes, because I like to include in my slides something absolutely bonkers and random, just to hopefully help cases to stick in your head. And today we have the Spice Girls song, Too Much. If you've not heard it, give it a Google. It is a banger, I can guarantee. Why too much? Well, we're talking about oversupply. Now, we all know that paragraph 74 of the framework tells us about the requirement to calculate a 5-year supply. And as part of that, there needs to be consideration of whether or not there is a shortfall in supply. Given that shortfalls are accounted for in policy and guidance, there has often been a question over whether or not oversupply should also be accounted for. And the framework is silent on that, it still is. But the PPG does have some reference to shortfalls, but only oversupply, but only where it's to offset past shortfalls, and that's at paragraph 32. So that's a bit of the sort of brief background context to this case. There we go. So I've put a little bit of a background there for you on slide 2, but just to give you a little bit more of a hint of it. Here in the Tewkesbury case, the joint core strategy was the development plan at hand, and that provided a total housing requirement of 9,899 over the plan period. By the time it got through the first 9 years, that stood at the 4,455 mark. But there had actually been an additional 1,115 dwellings delivered by that stage, so quite an oversupply. And perhaps understandably then, the council wanted to argue, and did in this case, that that oversupply should be taken into consideration. Now, when we look at the figures, we can see why that is, because that would have given them, albeit not a 5-year housing land supply, 4.37 years, so nearly there. Whereas if you took it out of the equation, you stood at 2.4, so nearly half of that. And if disputed sites were removed, it would have been an absolutely dire 1.84. So we can all understand why the council made the argument it did. What I'd suggest everyone does, and there'll be a link shortly in the chat to the judgment, is take a look at it, because there's a really helpful summary of the council's arguments in the inquiry context at paragraph 8, and also the inspector's reasoning at paragraphs 10 to 11. But ultimately, the inspector agreed with the appellant in this case that oversupply was not to be accounted for. And the council then, understandably, given its position, challenged the decision on 4 grounds. And we can see these at paragraph 33 of the judgment. The first one, I think, is the most key for us here, which was the suggestion that whilst the framework does not explicitly address the question of how past housing oversupply should be taken into account, the correct interpretation, the council said, is that it should be when carrying out a 5-year housing land supply assessment. In terms of the other grounds, ground 2 was effectively an alternative, that if the court is satisfied that the framework is silent and that the inspector didn't regard herself as prohibited from taking oversupply into account, it was irrational for her to not have done so. Ground 3 was an irrelevant considerations point. 2 points were suggested to not have been relevant. One, that the houses that had already been delivered couldn't meet the definition of deliverable. and secondly, that the housing requirement in the JCS wasn't a maximum. And then finally, we have our reasons ground at grounds 4, the suggestion that the inspector hadn't dealt with all of the points that the claimant had raised, but also that the inspector had failed to deal with a previous appeal decision that the council wanted to rely on, where it had been an agreed position that oversupply should be taken into account. So I've put here on this slide for you some of the key parts, in my view anyway, of Mr. Justice Dove's judgment at paragraphs 42 to 47, but these, just to be clear, concern ground 1. I will touch very briefly at the end on the other grounds, but these really are the key takeaways. Firstly, then, that the claimant's argument depended on a conclusion being a necessary inference from the way in which the framework had been drafted. Mr. Justice Dove said that it's not an inference which, in my judgment, can properly be drawn. 2, that in the absence of any specific provision within the framework, there is no text falling for interpretation. And just pausing there, of course, if there isn't anything written down for us to interpret, what are we looking at? It's a complete absence. But continuing on from that, it's not the task of the court to seek to fill in the gaps of policy of the framework. So it's not for the court to start searching around to effectively import into the framework things that just simply aren't there. Thirdly, the question of whether or not to do so will be a matter of planning judgment. So unfortunately, we are now therefore in a position that it's a facts and circumstances of the case. It's all up to the inspector, and you'll be tasked then with looking at whether or not the inspectors are rational in your view, based on whatever it is that the inspector has decided to draw into that discussion. And then finally, that whilst the council contended that the PPG should be mirrored, so whereas I said before, paragraph 32 allows for oversupply to be taken into consideration with regard to past shortfall, that should be extended effectively to also be the case where there's an oversupply but not a shortfall. Mr. Justice Dove said that there's no warrant here for drawing that inference. Now, you want to look as well at paragraphs 48 to 50, which just round off ground 1 in relation to whether or not the inspector proceeded on an incorrect basis, that she was prohibited from taking account of oversupply. In short, Mr. Justice Dove didn't think that that was the case. And then in terms of the last 3 grounds, as I said, there's no key changes, I think, here, no stellar points to take away, but just so you know, ground 2, paragraphs 51 to 52, essentially the inspector was acutely aware of the oversupply as a material consideration, did correctly conclude that it was a matter for her planning judgment, and did in her conclusion articulate the rationale for that. So no irrationality. Ground 3, paragraphs 53 to 54, so this is the irrelevant considerations point. When you look at the decision letter as a whole, neither of those points were freestanding reasons not to take account of the oversupply, so took matters nowhere. And then finally, ground 4, reasons ground. This probably doesn't come as a surprise to anybody. South Bucks case, we're all familiar with dealing with it. You're not obliged to deal with every point that's raised by a party. Mr. Justice Dove was satisfied the principal issues were addressed. The inspector's reasons were clear. And then finally on ground 4, in terms of the previous appeal, again, not a huge surprise to me, I'm sure not for others either. The previous case, everyone was agreed. So there was no academic discussion. The inspector wasn't, considering in depth or at all, really, the arguments. So this inspector was arguably for the first time considering the issues. There was no requirement for her to go back and comment on anything the previous inspector had said. So that's everything on Tewkesbury. If anyone's got any questions, please pop them in the Q&A. And over to Odette.
Brilliant. Before Odette starts, someone's asked about whether they can have copies of the presentation slides. They will be made available after the event, absolutely. And you'll see that I've put in the chat links to all of the cases that we're talking about today. So you'll be able to click on those links and that should open up your web browser so you can go back to that after this presentation. Thank you very much for that, Leanne. All a matter of planning judgment, as it almost always is. And with that, we'll turn to Odette. Thank you very much.
This new Court of Appeal case, Barkey and Dagenham against Persons Unknown, it's a bit different. It's not all about planning judgment, but it's an absolutely critical one for anyone involved in any kind of planning enforcement work, or anyone dealing with problems like nuisance or trespass on private land and looking for an injunction. So many local authorities, there are actually initially 38 sets of proceedings, had these borough-wide final injunctions against what the court described as newcomers. So that's people that were unknown and unidentified at the date of the final order. And they were effectively blanket bans on gypsies and travellers setting up residential encampments by occupying and trespassing on local authority land, be that parks, car parks, or commons. And the local authorities said they needed these injunctions. Injunctions are effective and they never knew who would be trespassing where or when, so they needed wide injunctions to make sure unlawful and sometimes dangerous behaviour didn't go ahead. But the problem for the gypsy and traveller community was this essentially meant that in large swathes of the country, there was nowhere they could stop. And that made the nomadic lifestyle they have, that's protected by human rights law, effectively impossible. And the whole nature of them not being named in the injunction was meant that they had no chance to stop it before it was in place. So the High Court gathered all of these injunctions together, and it found that this practice that had been going on for years up and down the country was unlawful. And Mr. Justice Nicklin essentially found that final injunctions just simply can't bind newcomers as a matter of law. And he based that on a 2020 Court of Appeal case about protesters outside the Canada Goose shop in Oxford Street. And there was a line in that saying you can't get final injunctions against unknown protesters. And this obviously had significant ramifications, not only for gypsy and traveller injunctions, but I was shadowing Richard Kimblin QC, who was representing HS2, who is often facing the sort of ever-evolving cast of protesters. They never know who will be there on a given day when important works are going ahead. So they need wide injunctions against unidentified defendants to proceed. And it was also relevant to apprehended breaches of planning control under Section 187B. So whether that's fly tipping, waste deposit, you might never know who it's going to be that's threatening to do that. So it had wide ramifications, and perhaps unsurprisingly, 15 local authorities appealed to the Court of Appeal. There was two bases to their argument. The first was an argument based on precedent. And if you're interested in sort of legal precedent and rules of ratios of cases and how different cases bind each other, this is a really good place to go for a discussion of that. But the precedent argument was, yes, there's this Canada Goose case, but there's other conflicting Court of Appeal authorities that actually suggest otherwise, suggest you can have final injunctions. And the local authorities said, essentially, Court of Appeal, you can pick which one to follow in this case. The second part of the argument was based on principle. And essentially, everyone agreed that you can get interim injunctions against unknown persons. And what the local authorities said was, why should there be this fundamental distinction between interim and final injunctions? And they pointed the court to the statutory basis for injunctions. So that's in Section 37 of the Senior Courts Act and 187B of the TCPA. And they pointed out that that's a broad power, and there's no statutory basis for the court confining injunctions in the narrow way the High Court had done. So the decision was the appeal was allowed, and to the relief of local authorities up and down the country, these final injunctions against unidentified newcomers were resurrected. So that's 187B planning enforcement, injunctions against protesters, against gypsies and travellers, protecting private land, all of that's allowed. But the key practical take home is that the courts are concerned by unnecessarily wide injunctions. And applicants, whether that be private landowners or local authorities, need to be really careful to make sure they do carefully follow the procedural and legal guidelines, some of which were set out and reminded of in this case. And I'll just pick out a couple that you need to be aware of if you're trying to get one of these injunctions against unknown people. So a really important thing is that you'll need to get an order for alternative service because you won't know the address of the defendant. So that's to post the claim, probably post the claim form and the injunction on the site rather than by normal post. You also need to ensure the injunction's as precise and narrowly worded as possible. Ensure that it's reviewed frequently and that it has clear geographical limits. And finally, if the case involves human rights, whether that be of protesters or gypsies and travellers, the injunction must be proportionate and fair, having regard to those rights. And specifically with regard to the gypsy and traveller community, the Court of Appeal said here that local authorities should make sure they engage in dialogue, that they do provide alternative sites where possible, and consider welfare assessments in some situations before getting such an injunction. So the key message is final injunctions against newcomers are allowed, but do beware of the procedural guidelines. Nina, over to you.
Thank you, dear and absolutely brilliant pupil. Let's see if I can get this done. I can't believe it. I've managed to do the tech. All right, I'm going to discuss something less exciting than ladies' underpants and national parks, but no less important, social housing relief. So this is the case of Stonewater 2 Limited, and it's important for me to say that Stonewater 2 is a registered, a not-for-profit registered provider of affordable housing. They are in fact a registered charity for the provision of affordable housing. And we'll see why that's relevant in a moment. But just to set the baseline for those of you who don't have the joy of knowing all about Reg 49 of the CIL regulations, this of course governs the eligibility for social housing relief, and you can see what conditions are relevant there. But we need not descend into the thicket of Regulation 49, because this case was about the principle, specifically the information that was required by way of Regulation 51, which provides that a claim for social housing relief must be accompanied by evidence that the chargeable development qualifies for social housing relief under Regulation 49. So that's the baseline. Those are the provisions. What is the case? The arguments before Mrs. Justice Thornton in this case, so Stonewater had purchased the site, which already had planning permission and a Section 106 agreement providing for 35% affordable housing in place. And that's not unusual for Stonewater. They regularly did this. They then applied for social housing relief at a 100% level because they were going to provide 100% affordable housing on the site, not 35%. The council countered that by saying the Section 106 agreement here controlled the amount of affordable housing at that 35%. A fresh or a varied Section 106 agreement was required. That's what the council said. The claimant, Stonewater, said, no, we disagree. That 35% is a minimum. Social affordable housing is a social benefit. It's highly desirable. Therefore, it makes no sense whatsoever to interpret this Section 106 agreement as requiring a max of 35%. We want to provide more, and it makes sense for you to accept that that can be provided under the Section 106. So in this case, the judge had to decide three specific questions: whether the provision of social housing relief is mandatory, pretty obvious question when you look at the CIL regs, but I'll confirm it later, whether the Section 106 agreement or a Section 106 agreement is a prerequisite to the grant of social housing relief under Reg 49, and how the Section 106 agreement in this case ought to be interpreted. And she had a very interesting approach to answering those specific questions that all of us can draw lessons from for our next applications for social housing relief, whether you're applying or determining those applications. So the Section 106 in this case specifically provided a definition, as they always do, of affordable housing units. Here, it referred to the 59 affordable housing units, which was obviously the 35% properly quantified. So the judge held that because of the language of the Section 106 agreement, it was not a minimum. It specified exactly how many units had to come forward. Very interestingly, she also had regard to Mrs. Justice Thornton to the officer's report relying on the expected CIL receipt quantum, which was going to be used to pay for the necessary highways mitigation. And here the Highways Authority had said, raised a red flag of a potentially severe impact on local highways infrastructure absent that mitigation being brought forward. And we all know that severe language is the trigger for adverse consequences under the MPPF. That was relevant. The judge noted it, but she quite rightly went on to say that's not a matter for the courts to decide. She didn't go into the merits or lack of merits otherwise for a mixed scheme as opposed to 100% affordable, because of course that is a quintessential matter of balancing public benefits and harms against each other, squarely the domain of a local planning authority, not for the courts. But she nonetheless did note that as being relevant. Now, to sum it up in one slide, slightly overly wordy, sorry about that, I'll sum it up orally for you. Three main conclusions came from this approach. So to benefit from social housing relief, it was the claimant's responsibility, having regard to Regulation 51, which provides there must be evidence. So it was the claimant's obligation to provide evidence demonstrating that it will bring forward whatever quantum of affordable housing, in this case 100%, that they were claiming the exemption for. Whether that evidence submitted under Regulation 51 suffices to satisfy the exemption under Reg 49 is entirely a matter of judgment for the council, subject to usual public law review in the courts. Quite right there. Back to Thea's point, everything's a matter of planning judgment. Now, an existing Section 106 agreement here did fix the affordable housing requirements at 35%. The absence of a corresponding Section 106 agreement locking that in was a relevant and material factor. And so I'm going to switch to the next slide. The decision ultimately, and this is notwithstanding the fact that Stonewater was a registered charity expressly required to provide affordable housing. So notwithstanding the identity and status and charitable obligations of the claimant here, and notwithstanding their assurances that they would bring forward 100% affordable housing, that did not suffice. So the council's complaints about the evidential difficulties because of the Section 106 agreement were relevant. And here Stonewater did not provide fresh or varied Section 106 agreement. There was no alternative to the Section 106 in this place that was in place in this case, because Stonewater's argument, of course, was that 35% was a minimum. They didn't need to, in other words, vary the Section 106 agreement. The judge disagreed here, looking at that, the language of that contract. Now, importantly, a Section 106 agreement is not a legal prerequisite for social housing relief. So that's not the outcome of this judgment, but it can form part of the evidential package or part of the evidence that's submitted in line with Regulation 51 to satisfy the obligations and the criteria under Regulation 49. So Section 106, not legally required, but it can be part of the evidence. And really, really important point, this final bullet point here, is that the judge found that to have granted the social housing relief here would have prejudged the exercise of the council's separate discretion to vary the Section 106 agreement or enter into a fresh new one later on. So audience, pay attention to the correct sequence here. If a varied or fresh Section 106 agreement, if that's required, get it in place first, because then the council cannot be accused of prejudging the discretion whether or not they're going to agree to that. And I'll come into the final bullet point, the consequences of that separate discretion here. But first, and you can stamp this on my forehead, the first part of the first bullet point here, because it's bog standard lawyers' advice. Pay attention to the language. Here it was the language used in the Section 106 agreement. So have clear regard to that. Simple point, but one that was missed here. You cannot here base a 100% exemption just on assertions alone. That's clear from the language of Regulation 51. There must be evidence accompanying the application for social housing relief. Look to what the applicant is legally obliged to do or not do, because that's your safe baseline to be satisfied under with the evidence under Reg 51. And the final point here, social housing relief is mandatory. That's obvious from the language of the CIL regulations. But if the applicant seeks a varied figure, a varied percentage of mixed and affordable housing to come forward on this site, if that requires a variation in what's expected to come forward by way of CIL receipts, the council is entitled, and I should think in most cases would, have regard to the CIL receipt that is foregone as a result of losing a percentage of market housing on the site. So to summarize the decision here, whilst on the facts, these are highly complex decisions, Stonewater and Wealden provides us with a very clear and straightforward set of principles with which we can tackle those very complicated and difficult facts in cases of social housing relief exemptions. And with that, I'm going to mute myself before I hand over to the marvelous Thea Osmund-Smith to present her final case.
Thank you very much, Nina. I'll take that introduction for sure. Now, just to say to everyone, get your questions in on the Q&A section. Lots of really good questions are coming in. So you'll see the panel scribbling away furiously in order to answer those questions for you in due course. Nina, as we thought, CIL has prompted a lot of debate. So you've got about 5.5 minutes to get answers to all of those questions while I talk about Cab Housing Limited. Once again, all of the links to these cases can be found in the chat. When we put this event together, I wasn't sure that we'd have judgment in this case. It is so hot off the press, being less than 2 weeks old. But fortunately, we have it, and it's all about permitted development rights. And it's a case in which I acted for the Secretary of State. And although Cab Housing Limited was the lead case, there are actually 3 cases before the court dealt with in the same judgment, because all of them raised the same issue of interpretation about the scope of Class AA of Part 1 of Schedule 2 of the GPDO. So there you go, a nice easy description for you there. But Class AA relates to enlargement of a dwelling house by construction of additional stories, 1 or 2, up to 2 if you like. But do you like? We'll see. The judgment is also relevant to those classes of development in Part 20, which concern the construction of new dwelling houses by upwards extensions, and Class ZA, which is the demolition of buildings and construction of new dwelling houses. So some of you might be aware of those particular permitted development rights in a more commercial context. But back to Class AA, that is a class of PD rights that requires prior approval. So the person who wants to exercise the right to extend upwards has to apply to the local planning authority for prior approval on a range of things, including here, the impact on amenity and also external appearance. And that's all set out in paragraph AA2, and then paragraph AA3 sets out the procedure. Unfortunately, at the end of the judgment, the judge annexed this particular part of the GPDO, so it's a really quick and easy reference to go there and have a look. Now, interestingly, just to draw this to your attention, paragraph 12 of AA3 sets out that a local planning authority, when determining an application for prior approval, must have regard to the framework so far as relevant to the subject matter. And so that brings in all of those issues of design, impact on heritage assets, and so on. And that's something that we don't find in relation to most PD rights, for example, the right to stick a shed in your garden. Now, what the court said about this process is that while an application for prior approval is not the same as an application for planning permission, because the authority is not entitled to have regard to the same range of material considerations as they would in an application for planning permission, the planning permission that's granted by the order only accrues or crystallizes upon the grant of approval and not before. So again, that's unlike other PD rights, which you're simply entitled to, providing you meet the relevant tolerances. So for example, is it so high? Is it so far from the boundary? In this case, you don't get to take advantage of those rights unless and until you have your prior approval. So what were these cases all about? Well, in all of the cases, the 3 applicants had sought prior approval and were refused. So they went along to the inspectorate and tried to get prior approval through a planning appeal. And again, they were all refused. And they were refused for pretty similar reasons, really. In Cab Housing, that was refused because the proposed heightened bulk of the building would appear over-dominant from the neighbouring property. So it would affect the outlook and harm the amenity of that property. And the inspector thought that it would stand out discordantly in the street scene. So 2 issues there, amenity and external appearances. And similarly, in Biesnoer and Rothenburg, which were the other 2 cases, there was this issue of dominance, bulky height, incongruous additions. And for Rothenburg, that was in a terrace. And the inspector said that it would appear discordant in terms of this additional height. Now, the idea of that bulky dominance was rejected by the claimant because what they said was that the GPDO established the principle of development of up to 2 stories by way of upward extension. And so it followed that if prior approval could be refused because of that same bulk and scale, which was prescribed within the order, then it would frustrate the purposes of the GPDO. The claimants also relied on decisions of other inspectors, which said that 2 stories should be regarded as acceptable in principle, because that's what the GPDO said. And so that was the baseline then for the assessments that those inspectors made. So it was clear that there was some inconsistency in this area, with different approaches being taken to this question of whether or not the GPDO established the principle of development. So at the heart of this challenge was the meaning of paragraph AA2 conditions, and particularly subparagraph 3A, which I've set out for you there. Now, that deals with, first of all, Roman number 1, impact on amenity, and Roman number 2, the external appearance of the dwelling house. And what the claimant said about that was, when we're looking at amenity, you can only have regard to overlooking privacy and loss of light, and that's it. And in cab housing, the inspector had said, well, this was a harm to amenity because of the outlook of the neighbouring premises. In respect of external appearance, what the claimant said there was that you could only have regard to the principal elevation of the dwelling house, because that's listed, and any side elevation of the dwelling house that fronts a highway. And the impact that the decision taker was concerned with was the impact on the dwelling house itself and not the wider area or the street scene. Now, you'll notice that in both instances of paragraph A there, 1 and 2, you see the word including. And that came to be very important because the claimant was saying that those definitions were exclusive. And what I was saying on behalf of the Secretary of State was that the word including is a word of expansion. And so as a matter of interpretation, the things listed there could be taken to be included, but it was not an exclusive definition. So that's what the claimant said. We've had a little bit of a look at that. And the point there, bullet point 3, about this principle of development being established by the GPDO, and therefore you couldn't interfere with that when you came to have or consider an application for prior approval. So what the judge decided, well, as we've discussed, a permitted development right subject to prior approval doesn't crystallise until that procedure is completed. And so the judge said it's not helpful to say that the GPDO established the principle of development without more, because while the GPDO sets maximum parameters, so in this case up to 2 stories, it doesn't follow that those rights are available to everyone. That will depend upon the planning judgment arrived at through the prior approval process. The judge also said that scale is controlled through the prior approval process, so it's not a given that everyone will be able to exercise those rights. For example, if any increase in height would have an unacceptable impact on amenity, for example, by blocking out light to a neighbouring property. And the word including was said by the judge to not be exhaustive, and limiting those definitions in the way that the claimant had proposed would involve reading extra words into the legislation, which simply were not there. So all 3 claims were dismissed. And the key takeaways for anyone dealing with these prior approval applications for upward extensions, both in respect to dwelling houses and other buildings, including those contained within Part 20, is that the impact on amenity is not limited to overlooking privacy and the loss of light, but will include any impact on amenity that might be relevant, for example, outlook from neighbouring properties. Adjoining premises within that relevant paragraph of the GPDO includes neighbouring and not just contiguous properties, which is what the claimants were contending for. So it could be that you would have an impact on the amenity of a property over the other side of the road, and that would be regarded as a neighbouring or adjoining property for the purposes of the GPDO. And in respect of external appearance, the decision taker is of course empowered to assess and control all relevant aspects of the external appearance, and not simply those which impact on the subject building. So it will have regard, or the decision takers will have regard to the wider impact of this proposal on the street scene, including by way of its height and bulk. So I think it's right to say that this permitted development right and those contained within Part 20 might not be as wide as initially thought. And perhaps those who are making applications for this type of permitted development through the prior approval process will have to take a little more time to think about the design rationale for the building and justifying that in terms of both its impacts on amenity and its external appearance, and the appearance in the street scene as well. So that is cab housing. Anna, I think you can take off the slides now. Thank you. And I'm going to hand over Leanne to go straight to questions. Thank you.
Thank you very much, and thank you to everybody that's sent in. We've had quite a lot of questions actually so far, so we're not going to be able to obviously deal with all of them, but we'll get through as many as we can in the time.
Oh, you've suddenly gone to mute.
Somebody didn't like what I was saying, but anyway, there we go. It wasn't me. Shane, you asked me a question. You said, are there any cases where oversupply and standard method have been challenged, where the council argues that oversupply should be accounted for and deducted from the standard method requirement when estimating the 5-year housing land supply? And then you've then asked to follow up, where does planning guidance stand on this? Now, I'm not aware of any cases to mind that deal with that. I've asked some of the group and nobody is aware of one. However, in terms of where planning guidance stands on it, the framework is still silent on oversupply, and the PPG, the only paragraph is the one that I referred to in my talk, which is paragraph 73, 72 leads up to that, which specifically deals with taking into account oversupply where you've got a past shortfall. So other than that, there isn't really any specific guidance that I can lead you to, I'm afraid. I think it's really very much a case of, again, it being a material consideration for the inspector to consider exercising their planning judgment, and then in terms of challenging that judgment, looking for signs of irrationality, which we all know is a very high hurdle to overcome. So unless any of the rest of the team have any points to make on that, I'm going to go to Sioned and ask you a question.
Yes, of course, Leanne.
There we go. So we have a lovely question from Sam Thomas for you, who's asked, in the context of Mclaren, how do you deal with the situation where the local authority won't agree that an owner does not need to be party to a Section 106? Any tips?
Yes, of course. So yeah, the ratio of Mclaren is that not all parties, there may be circumstances when not all parties need to be party to the 106. However, the bottom line here is that you really want to appease the LPA. You want them on side if you're dealing with them and they're dealing with your planning application. That may be less important if you're at an inquiry or an appeal, and the inspector can consider that material and justify it. But yeah, I think the overarching message is that you want the LPA on side.
Absolutely, I think that makes absolute sense. Odette, we've had a couple of questions for you as well. I'm just going to pick one out from Natalie Gordon on the chat. She's asked whether your case discussed links to the public sector equality duty, and also just a point of clarification whether or not the reference to EIA is a reference to equality impact assessment. If you can assist us on that, please.
Yes, of course. So yes, EIA equality impact assessment should have made that clear. But in terms of the public sector equality duty, it's not discussed in the Court of Appeal, but there is a paragraph 16 in the High Court, which makes clear that the recognition of Romani gypsies and Irish travellers, so those are the two separate groups. The Court of Appeal said there's also a group of new travellers, but those are the two main groups. As separate ethnic minorities is protected under the Equality Act. And so the public sector equality duty is engaged in these sorts of injunction cases.
Perfect. And then I have a question, then moving on from that, for Nina. Nina, you had lots and lots of engagement, unsurprisingly, I think, in relation to the exciting world of CIL. But there's a question I just want to ask you from Jonathan. He said that he's seen 100% affordable housing schemes dealt with by local planning authorities who said they'll only secure the percentage required by local plan policy through the Section 106, because anything beyond that isn't necessary. So then in that circumstance, 100% has been proposed, but only 40% secured by the Section 106. So his query is, well, in that context, that seems a bit harsh if such a Section 106 is then taken to effectively be more affordable housing being required. Is there anything that you want to say on that, Nina?
Yeah, I mean, my first answer is that what's necessary is a matter for the council. In that event, if that's the approach they take, then I would recommend going down the route of varying Section 106, because the test for agreeing a planning obligation is different to that, to vary one, and that's clear from the decision of Mr. Justice Garnham in Mansfield District Council. It's a 2018 case, so established by now. And in that case, he was considering under the application to vary Section 106, when the Town and Country Planning Act, Section 106, subsection 6, I think, when that says in considering whether to vary the planning obligation, the local planning authority has to have regard to whether it continues to serve a useful purpose. In Mansfield District Council, Mr. Justice Garnham made clear that that's not a useful planning purpose. That's any useful public purpose, even if it's not directly related to the underlying development or its mitigation. So a much wider test for the decision maker if you're applying to vary. So I would suggest going down that route, of course, if the council's amenable to that. And I should think if you're upping the ante on affordable housing, subject to the money from CIL that they might be relying on, that would be an open door, I should think.
Thank you, Nina. And because there's been so many questions to you, I understand you're happy to answer another one. We had one from an
Depends.
well, we'll see. We had another one from an anonymous attendee who said, should local planning authorities request claimants to spell out which conditions of Regulation 49 that they comply with in the relief form, or is it their duty as local authority to trawl through the agreement and figure it out?
Well, I think there's a second question from anonymous too, but I'm not sure if it's the same one. So I'll answer them in turn. In terms of the form, I'm as a barrister, I deal with the messy end of this, not the application form. So I haven't a clue what the form looks like. I should think you should specify what conditions you're relying on, because that's how the local planning authority ties the evidence that you're required to submit under Regulation 51 to the criteria and conditions under Regulation 49. So if you don't spell that out, I really can't see how, with any ease, the local planning authority can tell whether you do or do not qualify for that social housing relief. So my answer would be, it makes sense that you do specify those conditions. Trying to find the other one from anonymous. Leanne, you are the compere with 6 minutes, so I'll let you prioritize what questions we answer.
I think we'll go to Thea, because we certainly don't want to leave Thea out, and there has been a question from Katie on that as well. So for the prior approval process, with reference to the ability for the decision maker to have regard to the framework, would this include Greenbelt policy and the restriction on disproportionate extensions, Thea?
Yeah. Also, just before I answer that, there's a really useful observation from Robin Rossiter in the chat as well about the impact of agreeing 100% affordable housing in a Section 106 precluding funding from Homes England. So yeah, really interesting practical point there on affordable housing and grant funding that might be available. But yeah, it's a really tricky one, isn't it? Because permitted development rights aren't withdrawn on Greenbelt land, of course, unless, of course, you've got a more recent planning permission. Local authorities seem to like slapping a condition on more recent permissions withdrawing those rights. But let's just assume for a moment that you're in the Greenbelt and you don't have your permitted development rights withdrawn. Technically, you do have the ability to make an application for prior approval for these. But as I mentioned when I was giving my presentation, in paragraph AA3 of Class AA, it tells us at subparagraph 12 that the local planning authority must, when determining an application, have regard to the national planning policy framework, so far as relevant to the subject matter of the prior approval, as if it were an application for planning permission. So it's sort of, that is a really interesting and important paragraph that could prove decisive, I think, when it comes to applications for this sort of development in the Greenbelt, because you just don't find that in relation to the more kind of vintage suite of permitted development rights that we're used to dealing with, ordinary house extensions and classy, structures in the garden, that sort of thing. They don't require a decision taker. Well, you don't have to apply for prior approval, so you don't then engage the framework or anything else. So certainly the decision taker, whether that's a local planning authority or an inspector on an appeal, is going to be looking at the framework and the extent to which that supports the development or otherwise. And I think it's going to be tricky in terms of Greenbelt. I mean, it's important and it's material that this is set out in the general permitted development order and it's not withdrawn for Greenbelt land. That is something you are going to be saying to the inspector. But when a local planning authority or an inspector can have regard to the entire gambit of national planning policy and also the impact of any development on the wider street scene or its landscape context, if you're not looking at a street scene specifically, then that is going to limit the extent to which these rights are available to those people.
Absolutely. Good stuff. Well, we've got three minutes left, so not very long, but I just want to point out one thing that David has mentioned in the chat, David Lomuth. He's pointed out in relation to the oversupply case that if you include oversupply, then perhaps you should also include any shortfall if you're applying planning judgment. I mean, certainly that's one of the arguments that you'd raise. If you're going to, want to refer to one thing to your benefit, you need to have it all considered. But again, it still falls back to material considerations and what the inspector considers in the facts and circumstances the case is appropriate in applying their planning judgment. So it really is one, I think, that you need to drill down on a case-specific basis. But for me, that makes sense. Thea, I think you dealt with a case, didn't you, in East Riding?
Yeah, so not particularly on the oversupply point, But just in terms of housing land supply generally, you know, this is a creature of the National Planning Policy Framework. It is therefore policy and not statute. And when you've got policy, you can abide by the policy, you can depart from the policy if there's good reasons for doing so, and you can justify it. And those were the points that we faced in East Riding, was that we should be departing from national planning policy in the way that the supply was calculated, because there was a really good reason to do so, and people can go and have a look at that judgment and see how that worked out. But that's the straightforward point. I think when we're looking at housing land supply, it is policy, it is all a matter of planning judgment, and there are going to be a vast array of particular circumstances that you can call into the arguments to weigh in favour or against your approach, and just put the most compelling case to the inspector, in the context, of course, that we are seeking to boost significantly the supply of housing in the context of a national housing crisis. So I think whatever approach is going to best achieve those aims and ambitions is likely to find favour with an inspector. I
think that's absolutely right. And it's a message that we're having drilled to us all the time, isn't it? It's not going away. It needs to be addressed. And so certainly something that would need to be considered in the round in advancing those arguments. Absolutely. Well, thank you very much, everyone, for answering those questions. Good stuff. Thank you all. Thank you to all of our attendees. We really hope that you've found that useful. The slides will be available following this, as will a recording of this session, so that you can go back and watch it again. Share it with your friends, your family, anyone who wants to see it. And we really hope to see you in person sooner rather than later. Thank you all very much.
Thank you, everyone. Bye-bye.
Thank you, everyone. Bye. Bye.